The only two things that we have here today that we can do, I believe, as I read our policy, is either affirm the decision of the Student Disciplinary Hearing Authority or grant a hearing. Those are our two options as I understand, unless someone has a different understanding of the policy. If you need more time to look at this, we'll allow that. If not, then we'll hear a motion to take whatever action that you think.
Mr. Chairman, I make a motion that we grant them a hearing.
Motion's been made to grant a hearing. Is there a second?
I second.
There's a second. Any discussion? Hearing none. Ms. Michael, please call the roll.
Hicks,
Yes.
Chris,
Yes.
I'm sorry, Mr. Christian. Craddock,
Yes.
Helton,
No.
Shannon,
No.
Jeff, Mrs. Charles,
No.
Larkin,
No.
4-3.
The vote is 4-3. The motion did not pass. As a point of business, would we need a motion to affirm, or does that affirm? Does that vote affirm?
I don't think that vote affirms. I think you need a motion to affirm.
That's kind of what I was thinking as well. With that, do I hear a motion to affirm, since that's the only thing left?
I would make that motion.
Motion's made to affirm the decision of the Student Discipline Hearing Authority. Do I hear a second?
Second.
Second by Ms. Charles. Any discussion? Hearing none, call the roll.
Hicks,
No.
Christian,
No.
Craddock,
No.
Helton,
Yes.
Shannon,
Yes.
Charles,
Yes.
Larkin,
Yes.
4 yes, 3 no.
Motion passes to affirm the decision of the Student Discipline Hearing Authority. Is there any other business to conduct?
Mr. Chairman, I would like to ask if this is a valid meeting since we are in violation of policy 1.402. States where any special called meeting has to have a place, a time, and a purpose, and the purpose was not divulged in the posting. Just a question.
It has been raised on our website. The purpose of the meeting was on our website. It's something probably we can do better to add it in all places when we do a posting, but I'll rely on counsel that met the necessary notice that it was on our website to correspond with the notice that was in the media.
My understanding was that it was on a posted agenda, yes.
Just like
It
it
was
was
posted where?
on our website.
Is that currently posted? Okay. No, I'm good.
I didn't look at it myself personally.
I don't know that I can be heard, but I have the website in front of me. My name is Troy Boland. I did send a request. I represent Mr. Armstrong, and I did send a request respectfully, Mr. Larkin, to be heard today. That request was neglected to be responded to. I haven't got a response back, but I'm staring at the website. And on this website, it says the Hawkins County Board of Education will have a special called board meeting on Tuesday, October the 16th, 2018 at 6 p.m. at the Charles A. Fuller Board Room and Training Center. I encourage someone to enlighten me as to where the purpose of this meeting is contained on this website.
I'm relying on our staff. Is it a? Okay. So I'm told that it was not put on there. Okay.
And if the board continues and accepts the vote, I still request an opportunity. I won't take longer than 3 minutes than to be heard. I would like to be heard. If this board is going to consider this a valid meeting, I would ask for the opportunity to be heard.
We would like to consider it a valid meeting on behalf of the student. We want to do what's right for the student and try to move through this. Let me just poll our board members. Individually, Mr. Boland's requested a statement. After you make a statement up to 5 minutes, are you good with that, Mr.
What
H.S.?
difference does it make at this point if he says anything to this board, because this board's already voted and affirmed the vote? And as far as I'm concerned, if you want to get right down to brass tacks, this whole thing is out of order. It all violates policy. Even the hearing, even this hearing violates our policy.
The question is,
Because this board, that authority has never, and I'm going on my 5th year on this board, and it has never been appointed by this board in my 5 years, going on 5 years on this board. I asked the question today, when did we authorize this particular authority? And I got the response, well, it's always been. Well, not according to policy, it hasn't always been. It's an annual appointment by this board. Now, either we're gonna go by policy or we're not gonna go by policy. If we're not gonna go by policy, let's quit.
Point of order. We're here. Policy. We're here for this one purpose, Mr. Hicks, and I respect that.
I move we adjourn.
Well, is there a second?
Second.
Any discussion? All those in favor of adjourning, let it be known by saying aye.
Aye.
Those opposed? No.
You gotta bring up another piece of business.
The business that I've proposed to the board is, do you want to allow Mr. Boland the
Gotta
opportunity
be something
to be
else.
heard?
It's gotta be something else.
It's regarding what we're here for tonight. Yes or no, please?
No.
Mr. Christian?
Yes, I'd like to demonstrate.
Yes. Yes. Yes.
Okay, I would too. Mr. Boland, if you would please,
Thank you for this opportunity. My name's Troy Boland II. I'm a founding member of the Boland Law Firm, and I represent has been criminally accused of a crime. Mr. Wines, the principal of Volunteer High School, stated that this Student Disciplinary and Hearing Authority, the reasons why he believed Mr. Armstrong, a dual enrolled student, top of his class, should be expelled. And in his statement for expulsion, he said, and he relied on statements given to him by law enforcement. Law enforcement who have a self-serving interest in providing statements. They're not going to say it didn't happen. They could subject themselves to civil liability if they were to say that. What they said was that this happened. And Mr. Wines, with all authority, refused to conduct his own investigation. Wouldn't we all hate it if we were being investigated and we relied on 2 or 3 statements of hearsay to convict us? Doesn't God Almighty in Deuteronomy require more than that? So what Mr. Wines has done, he's relied on these statements, and he didn't conduct an independent investigation. He didn't go out and interview the students. He didn't go out and interview the parents that were in the stand. We've interviewed them. We have conducted and are in the process of conducting our own independent investigation, and it's not in line with the self-serving statements of law enforcement. What this board has the absolute power to do is to order an independent investigation as to what this young man did or didn't do. And what he didn't do is what he's criminally accused. We just seen this in Supreme Court Justice Kavanaugh and the joke that was played on him and what he had to go through because there was accusations on him, whether true or not. Our system is not built around you're guilty until proven innocent. That's what this board just approved. They sanctioned and ordained that Mr. is guilty before he proves his innocence. That's not the system of justice. The School Disciplinary Hearing Authority, that Mr. was required to go to in a short period of time, the lack of due process, it doesn't allow him the opportunity to subpoena law enforcement officers. There's no powers granted for him to present anything other than his own statement, an own statement that if he gave while he's under criminal prosecution could be used against him. We all enjoy the Fifth Amendment right to remain silent. Some people should exercise it a little more often than they do. This young man did because his lawyer told him to. We asked for the opportunity to ask Mr. Wines just a few questions. Where'd you get your data? Where did the data come from? Did you talk to anybody else? Before we could ask one question, Mr. Smith said, no, that's not what this is about. You don't get the right to ask questions. When Mr. mother spoke and offered testimony after Mr. Wines had put on his testimony, his narrative of events that he received from somebody else, guess what Mr. Smith turned and asked the members of that student disciplinary hearing authority? Do you have any questions for her? And they asked questions. Ron was not given that opportunity to ask one question. Not one question. This meeting does not comply with the rules this board has set and the purposes of this special so-called meeting. I would imagine if the purpose of this meeting would have been published as required, that we would have more individuals here in this room this afternoon. Maybe that's the reason it wasn't published. I don't know. But I know the purpose was not published. And if this board wants to take the position that they're going to proceed with a meeting that is highlighted and represented to be in violation of a policy they created, that the board will lie on that bed. I'm asking this board to reconsider whether this meeting is valid or not, and then to conduct a valid meeting after an appropriate publishing to determine whether Ron should be allowed back in school pending the outcome. Has been accused of a crime, and he was expelled from school. Individuals, he's been in school since he was 5 years old, taken out because of accusations. Thank you.
In view of allowing Mr. Rowland to make statements, I would see if our counsel wishes to make any statements as well. If you want to respond to any of that, or
Mr. Chairman, I don't think that there's a role for lawyers to be presenting positions that are outside the record, and I don't intend to do that unless you have specific questions.
I don't have any specific questions, and I didn't know if you had any rebuttal that you wanted to add to that. So with that said, is there any other business? I hear a motion to adjourn.
I so move.
Second.
Second.
All those in favor, say aye.
Aye.
Those opposed, like sign.
Our firm is currently investigating the allegations against Mr. Armstrong. We feel sure that the allegations that are lodged are not relied upon credible information, and we believe that at the end of our investigation, the conclusion would reveal that this man has been criminally accused of a crime he didn't commit, and as a result of that crime, he has been expelled from school.
Okay. So is there any recourse you have after this? Is there appeal beyond this board?
We'll investigate the process that can flow out of this. What I believe has happened today is that it's an inadequately noticed meeting, and I believe that they refused to acknowledge that and conducted a vote and conducted business in violation of their own policy and possibly in violation of the sunshine law. Don't know that, but that's something we'll be looking into.
Okay. All right. So you just told me you were a witness to this event of this youngster?
Yes, I was in attendance of that football game.
Well, tell me what you saw.
I saw a bunch of kids being thrown around and a lot of law enforcement on the track and kids being handcuffed. And I thought to myself, now I have the utmost respect for law enforcement. Don't never question that, but I also have a lot of respect for students and students' rights. And I think that it just got out of hand.
On the part of who?
The students, the law officers, and our administration.
Well, one of the students who's on your school board, who your student school board representative, said he felt like the reaction of the law enforcement was over the top.
I have to agree with that to an extent. I did question one officer and said that the person spit in one of my officers' face, and that's not tolerable. I agree with that, but testimony from a meeting, it was never concluded that an officer got spit in their face. The way I read it, it was spittle, possible. So a lot of conclusions were jumped to when we got kids involved at a high school football game. Not a meth house, not out drinking, at a high school football game.
So what are your thoughts on the validity of this meeting, what just
I
happened?
think it's a farce,
Yeah,
an all-out farce.
yeah.
Policy was not followed in any form or fashion. I question the last hearing that this student went to, the validity of the people that was on that. Policy states that those folks are supposed to be approved by this board. I can't find evidence where they were approved. If we're going to have policy and we're going to hold other people to policy, this board, first and foremost, has to stand on top of policy.
Well, who's on that committee?
Wes Smith, Greg Sturgill, and Denise McKee.
Was it unanimous to expel?
Yes,
Okay.
but that was already done. They just affirmed. They just affirmed. The other problem I had from the transcripts that was shared with me, I got no information until Friday, this past Friday, as a board member. I had no information whatsoever of anything taking place. And when I read the transcripts, my concern comes from the testimony that was given in that hearing, is that the principal did no further investigation other than talk to the law officers there that night. And I'll say it again, I respect law enforcement across this country. They represent what's good, and they keep the peace. They keep it safe for me and my family, and as well as you. But this is America. We have rights. Whether you like the processes or not, that student was proven guilty before an investigation was complete.